Welcome to the Explainer. Today, we're literally opening up the legal toolbox to see exactly how the law fixes broken agreements. We're going to be diving into two absolute pillars of Indian law, the Indian Contract Act of 1872 and the Specific Relief Act of 1963.
It's a highly relatable human experience, isn't it? Two people make a deal, shake hands, sign on the dotted line, and then, well, things just fall apart. Someone doesn't deliver, or someone doesn't pay. So what actually happens then? The law doesn't just throw its hands up in the air. No, it has incredibly precise, calculated remedies designed to step right in and fix that broken promise.
To navigate all this, we've got a clear map for today. When contracts go wrong, financial fixes like damages, the concept of as much as earned, enforcing deals through specific performance, stopping harm with injunctions, and finally, fixing or canceling contracts outright.
All right, part one, when contracts go wrong. Let's ground ourselves right in the basics of the Indian Contract Act.
Okay, so let's dive right in by clarifying the foundational philosophy of Indian contract law. When a contract is breached, the injured party obviously suffers a loss. But the law's goal here, which actually comes from English common law, is not to financially ruin the person who broke the promise, just out of spite. The objective is simply compensation, not punishment. We just want to restore fairness and put the injured party back in the position they would have been in if the contract had actually been performed properly.
Moving to part two, financial fixes or damages. That brings us perfectly to the first main compartment of our toolbox, which focuses entirely on, well, throwing money at the problem. In the legal world, we call this financial fix damages. Simply put, damages are monetary compensation awarded to the injured party for the actual loss they suffered. It's basically taking a financial loss and applying a financial fix to maintain commercial certainty. Now, courts recognize several types of damages, ranging from nominal to aggravated. For instance, you've got general damages, which just naturally arise from the breach. Special damages apply if there were unique circumstances communicated right up front, or liquidated damages, where the exact amount was pre-agreed in the contract itself. But here's the absolute critical rule, established by the super famous Hadley versus Baxendale case. The loss cannot be too remote. Simply put, if you couldn't have predicted it, you can't claim it. Part 3. As much as earned. Now, what happens in a really unique scenario where strict contractual remedies just don't cut it? Say a contract was only partially finished or someone did a bunch of work for you without a fixed price. Well, in these cases, we rely on a doctrine called quantum meruit. Now, this heavy Latin term translates simply to as much as earned or as much as deserved. It allows a person to recover reasonable remuneration for work done or services rendered. It's an equitable remedy, and it's specifically designed to prevent unjust enrichment. Basically, if someone lawfully does work for you and you enjoy the benefit of that work, you can't just refuse to pay them just because a formal contract wasn't completely finalized. What's actually really fascinating here is the clear separation between recovering a loss versus getting paid for your actual value. See, damages are all about compensating you for a broken promise based on the loss you suffered. Quantum meruit, on the other hand, is about paying you for the work done based on the benefit the other person received. And get this, it can arise completely independent of a contract breach. On to part 4, enforcing deals through specific performance. Let me ask you this. What if money just isn't enough to fix the problem? For that, we pivot over to the Specific Relief Act of 1963. When financial compensation falls short, the court can pull out an action tool called specific performance. This is a discretionary court order that actually directs the defaulting party to perform their contractual obligation. We use this for truly unique situations where money simply cannot replace what was lost. We're talking about things like the sale of immovable property, a rare painting, an antique, or maybe a one-of-a-kind family heirloom. But, and this is a crucial point, courts won't force everything. If monetary compensation is adequate, they'll just award damages and call it a day. They also won't enforce personal service contracts. I mean, you simply can't force an unhappy singer to give a good performance against their will, right? Plus, courts won't touch contracts that require continuous daily supervision because, let's face it, a judge doesn't have the time to micromanage your business operations every single day. There are also personal bars to this relief. Think of this as a super strict checklist the plaintiff has to pass. You cannot demand specific performance if you've already gone and obtained a substitute somewhere else.
And most importantly, you must show continuous readiness and willingness. If you didn't have the money to pay your end, or you acted fraudulently, the court is simply going to deny you this favor outright.
Section 5. Stopping harm with injunctions. Let's move to the next compartment of the toolbox. Tools specifically designed to prevent wrongful acts from happening in the first place.
So, an injunction is essentially a court order to do or not do a particular act. A temporary injunction is basically the legal pause button. It's granted for a limited period while the lawsuit is still pending. The whole goal here is just to preserve the status quo and prevent any irreparable injury while the court takes its sweet time to figure out the actual facts of the dispute.
Now, notice how this temporary pause can build into a permanent, lifelong stop order once the final hearing concludes. That is a perpetual injunction. It permanently restrains the defendant based on the court's final decree, settling the matter for good.
We also categorize injunctions by what they actually demand. A prohibitory injunction restrains a party from doing a wrongful act. A really great business example deals with enforcing negative covenants. Imagine an employee promises not to share trade secrets with a competitor. If they try to do so, a prohibitory injunction legally stops them right in their tracks, protecting the employer's commercial interests. Contrast that with a mandatory injunction. Instead of stopping an action, this compels the performance of a positive act to restore the original position. For example, if someone illegally builds a brick wall on your property, a mandatory injunction is the tool the court uses to force them to physically tear that wall down.
Finally, Part 6. Fixing or canceling contracts. Because sometimes the problem isn't just the behavior of the parties. Sometimes the written document itself is fundamentally flawed.
The Specific Relief Act actually gives courts the power to fix the paperwork through three main methods. First up is rescission. This is canceling a contract entirely because it's become unlawful or voidable, which restores everyone to their original positions. Second is rectification. If there was a mutual mistake or fraud, like say a missing zero in a purchase price, the court can actually rewrite or correct the instrument so it reflects the true original intention of the deal. And finally, cancellation allows the court to formally void a defective document that's likely to cause serious future injury, essentially ripping it up to protect an innocent party. And, this brilliantly illustrates the entire philosophy of the Specific Relief Act. Remedies like specific performance, injunctions, and document cancellation are entirely discretionary. They're based on good conscience. The underlying rule is, he who seeks equity must do equity. Basically, to get these special favors from the court, your own hands must be completely clean. You must have acted honestly, fairly, and in total good faith throughout the entire transaction.
So, we've explored the differences between financial damages and quantum merit, and we've unpacked the really powerful, equitable tools of specific performance, injunctions, and contract corrections. The law absolutely provides a robust toolbox to restore fairness when promises are broken. So, as we wrap up this explainer, I'll leave you with a challenge. Review the contracts you rely on daily. How ironclad are your own agreements? And honestly, if things went wrong tomorrow, which tool from this legal toolbox would you need to make things right?